Hello friends, in the series on income tax cases today we will discuss a totally different issue which has come before the Ahmedabad ITAT D bench. The issue before the Honorable Tribunal was that if some assessment under section 147 is being done and in that assessment if the assessing officer chooses not to make any addition and if the assessee after having the nil assessment do not challenge the assessment order with the CIT appeal and by not filing the appeal it is not possible for the assessee to challenge the reopening because the assessment has been done in favor of the assessee, and if in that case the revision proceedings under section 263 is being initiated for that order, so whether in that case the assessee will be entitled to challenge the reopening in section 263 proceedings. This issue has been taken up by the Ahmedabad ITAT D bench in the case of Raman Bhai Chetha Bhai Jadhav versus Principal Commissioner of Income Tax, and this case is reported in 135 ITR Tribunal Short Notes 1 and the date of the judgment is 6th February 2026. The present case relates to the assessment year 16-17. In the present case, the assessee has not filed its return of income. The assessing officer got the information that the assessee has some profit derived from equity derivative trading, and to examine that profit or that income, the notice under section 148 was issued to the assessee. In response to the notice under section 148, the assessee filed the return of income at a figure of rupees 3 lakh, and when the return was filed and when the reasons were asked by the assessee raised serious objection to the reopening under section 147 by taking the various objections regarding the discrepancies in the reasons recorded. Somehow the assessing officer didn't make any addition in the assessment order and the assessment order was passed. It may be that the assessing officer is satisfied with the objections of the assessee and has not done any addition. When the assessment order was passed without making the additions, the learned principal CIT was of the considered view that the order passed by the learned assessing officer is erroneous and prejudicial to the interest to the revenue, and this is a fit case for initiate the proceedings under section 263, and hence the principal CIT gave the direction to the learned assessing officer to pass the fresh assessment order. The assessee filed the appeal before the tribunal by challenging section 263 proceedings on the ground that the order was not erroneous, and at the same time the assessee took the plea that the section 263 proceedings has been based on audit objections and it is on the borrowed satisfaction of the audit team. When the tribunal heard the matter, because the assessee also challenged the reopening in section 263 proceedings, the tribunal said that since in present case the assessee has not filed the appeal before the CIT appeal and has not challenged the reopening, so the assessee cannot challenge the reopening under section 263 proceedings. According to my view in this case, somehow it seems that the important point has been missed in these proceedings, that the assessee has got nil assessment. So in that case, how the assessee will file the appeal before the CIT appeal? So without appreciating this aspect, I think in the present case, with the due respect to the Honorable Tribunal, in the present case, the appeal of the assessee was dismissed on the sole ground that since the assessee has not filed the appeal before the CIT appeal and has not challenged the reopening, it was held that the assessee cannot challenge the reopening in section 263 proceedings. At the end of this video, once again I am repeating the name of the case. The name of the case is Raman Bhai Chetha Bhai Jadhav versus Principal Commissioner of Income Tax, and this case is reported in 135 ITR Tribunal Short Notes 1 and the date of the judgment is 6th February 2026. Thank you, friends.